John, let's talk about, first of all, if the plaintiff has established anything with this witness. The plaintiff really came up against wall after wall after wall because of what's called a lack of foundation. First of all, describe what a foundation means.
Well, before any witness can testify, an expert witness, as to his opinion, you have to lay a foundation. What it is you reviewed, make sure that it's accurate. He can't just come in and base conclusions on hearsay or some other not factual information. And here what happened is he didn't see all the documents that he probably should have looked at. So there were two ways to handle it. You could have had the agent get on the stand first and describe everything she did and the report she prepared for the expert, or have the expert look at everything. The judge, I think, gave it away a little bit there, because when she was done, she said, I think when we get through it all, I don't know how much he actually testified to.
I know, that must be disheartening for the plaintiff's lawyer to hear. But yet she offered him assistance. She offered him a hand at the end. She said, would you like me to phrase it for you? And he refused it. Do you ever refuse a judge when they're especially going to make the decision?
Sometimes in front of the jury you would, because you don't want to be one-up by the judge in front of the jury. But here there's no jury. And if the judge is helping you, because it has to be a record here. If he loses, you have to have made your foundation. If the judge is saying, let me put it in a way that's acceptable, obviously if the judge asked the question, she can't overrule her judgment. And he said no, and then he sat down, basically. So, you know, the judge is probably looking to fill in a gap in her mind, because the other lawyer is going to move to strike his testimony.
But if the judge wanted to, depending on the style of the judge could have just interrupted and asked the question herself, because she has to, she's the fact finder here instead of the jury, and she needs information that maybe she's not getting from his questioning, but this judge probably doesn't have that style.
No, and when the lawyer says, no, I don't need your help, okay, she sits back.
It's your case.
It's your case. Do what you want.
Now, I imagine that the plaintiff's lawyer also, and perhaps the plaintiff, may have felt the floor going out from them when the witness said, was asked about what would happen if there were no contract, and he said, well, what would it be? I don't know. I've never dealt in a situation like this, because they're in the position where if the judge finds that there was no contract, they still want to be compensated.
Right. I think what the lawyer would have liked the expert to say was, well, if there is no contract, and the amount of work she did, that was consistent with someone getting 50% of the licensing. That's what you really wanted him to say. This was good work, and that would be a 50%er, not a 35 or less. He didn't give that to him.
All right. Well, there's a lot more to come. It's just starting. John Carro, and thanks so much for being here to help us with the beginning of it. We're going to take a commercial break.